Hello, this is Jason Mortimer, EDU 503, assignment 4.2. The court case that I have chosen to present upon is Gebser v. Lago Vista ISD. This is a Title IX case revolving around sexual harassment, specifically the conditions that a school district can be held liable for when a teacher sexually harasses a student. This is a landmark Title IX case that defines the school district's responsibility and the standards for liability in harassment cases as it pertains to Title IX. So the facts of the case, it involves Alita Starr Gebser, a student in the Lago Vista Independent School District. So Gebser was an eighth grade student who later became a high school student within the district, developing a relationship with one of her teachers, Frank Waldrop. Waldrop had a pattern of making inappropriate comments in class, typically sexually suggestive in nature, and eventually began a sexual relationship with Gebser. Most importantly, Gebser did not report the relationship to the school officials. And at one point, there was a time where parents of other students had begun complaining to the principal about Waldrop's inappropriate comments in class. And it was found that the principal did not escalate the issue or report it to the Title IX coordinator. The relationship was ultimately discovered by police, which led to Waldrop's arrest and subsequent termination. And this is where Gebser then sued the school district under Title IX, seeking damages. One of the central disputes arose regarding what the school district knew about the relationship and Waldrop's conduct in class, and when they knew it. So some of the key legal issues: when can a school district be held liable for damages under Title IX, specifically when it revolves around teacher sexual harassment of a student? Is the school automatically responsible for it? Is it enough that the school should have known, or must the school have actual factual evidence, knowledge with evidence of the misconduct prior to being held liable? Now, the plaintiff's arguments, Gebser argued that the school district should be held liable under Title IX because she claimed that the district failed to properly monitor Waldrop's actions, which led to them not being able to prevent any of the misconduct from Waldrop. So her argument relied on two main points, right? Vicarious liability, which means that the school should be responsible for the actions of its employees, in this case, Frank Waldrop. And then the second, constructive notice, meaning that the school should have known about the misconduct based on the warning signs, based on the prior complaints, based on prior actions. The school should have known. So she also points out that the school district failed to implement any sort of proper sexual harassment policy or grievance procedure throughout this entire case or investigation into Waldrop. Now, Lago Vista ISD argued that it should not be held liable because it didn't have actual knowledge of the relationship. Only complaints, secondhand information, in their opinion, from students and parents of students. So they emphasized that there was no school official with any authority to take action who knew about the conduct. So there was nobody in administration, there was nobody like an SRO who was able to take action because they didn't have any factual evidence of misconduct. And then they also argued that Title IX is not meant to impose any automatic liability, especially when the school district had no opportunity to respond or correct the situation. So this court case ultimately went all the way up to the Supreme Court, and the Supreme Court ruled in favor of the school district. They established a key legal standard that a school district can only be held liable for damages under Title IX when, um, I guess, if it meets the following conditions. So, an appropriate school official has to have actual knowledge of the misconduct with evidence, and that the school responds with, in their opinion, deliberate indifference. The court rejected both vicarious liability and constructive notice as bases for damages. Um, they reason that Title IX operates like a contract. School receives federal funding in exchange for agreeing not to discriminate. They found that Lago Vista did not discriminate just because they did not have any clear notice or any evidence of wrongdoing at this time, just secondhand knowledge. So in this case, they said only the principal knew about inappropriate comments made in class, not actual sexual misconduct. So the school did not have any sufficient notice. That was their claim. So as a result, the school district was not held liable. So the implication for athletic administrators, this case has established that school districts are not automatically liable for employee misconduct, that actual knowledge is required, and that the failure to act must rise to this deliberate indifference. But, we as athletic administrators need to report any concern seriously, immediately. Sorry, we take any reports seriously and report them immediately. I mean, we are mandatory reporters, right? We need to make sure that we have proper policies in place. Training, especially regarding Title IX and sexual harassment, is beyond essential for our coaches who are in close proximity to our student athletes. And if we just without the mandatory reporter side of things, ignoring or minimizing complaints can create this liability. Even if we don't have any actual knowledge, we can go to our SROs, go to upper admin, and request a start of any investigation, so that we are ultimately minimizing any sort of liability on our end.